By the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other party, therefore, a price certain in money or its equivalent. The essential elements of a contract of sale are consent or meeting of the minds, that is, consent to transfer ownership in exchange for the price, and determinate subject matter, and price certain in money or its equivalent. Consensual is a contract of sale which is perfected by mere consent. That is, at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. If there is already a meeting of the minds, either of the parties can no longer unilaterally withdraw from the contract. In a sale by auction, perfection is when the auctioneer announces its perfection by the fall of the hammer or in other customary manner. Reciprocal, both the seller and the buyer have corresponding obligations to give under a contract of sale. The buyer is obligated to pay the price while the seller will deliver and transfer ownership of the thing sold. What is onerous? The price is the valuable consideration for the delivery and transfer of ownership of the thing sold. Examples: 1. K and Company published in the newspaper an invitation to bid, inviting proposals to supply labor and materials for a construction project described in the invitation. L, M, and N submitted bids. When the bids were opened, it appeared that L submitted the lowest bid. However, K and Company awarded the contract to N, the highest bidder, on the ground that he was the most experienced and responsible bidder. L brought an action against K and Company to compel the award to him and to recover damages. Is L's position meritorious? Answer: L's position is not meritorious. There is no enforceable contract between L and K and Company. Article 1326 of the New Civil Code provides that advertisements for bidders are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder. Hence, L merely made a proposal when he submitted the bid. K and Company has the right to reject the proposal or to award it to somebody else. Number 2. X offered to buy house and lot of Y for $300,000. Since X had only $200,000 in cash at the time, he proposed to pay the balance of $100,000 in 4 equal monthly installments. As the title to the property was to be immediately transferred to the buyer, X, to secure the payment of the balance of purchase price, proposed to constitute a first mortgage on the property in favor of Y. Y agreed to the proposal so that on April 15, 1987, the contract of sale in favor of X executed, and on the same date, X constituted the said first mortgage. When the first installment became due, X defaulted in payment thereof. Y now brings an action to rescind the contract of sale, which X opposed. How do you decide the conflict? Give your reasons. 1989 bar. I will decide against Y's action for rescission. Y can no longer rescind the contract of sale. The problem indicates that the contract of sale was already perfected and consummated with the transfer of ownership to the buyer. With the transfer of title, the relationship was already converted into a mortgagee relationship, and it is no longer proper to rescind the contract of sale. If X will not pay despite demand from Y, the remedy of Y is to foreclose the mortgage. Actual delivery means actual physical transfer of control and possession to the vendee buyer. A stipulation designating the place and manner of delivery is controlling on the contracting parties. The thing sold can only be understood as delivered to the buyer when it is placed in the buyer's control and possession at the agreed place of delivery. Constructive delivery includes execution of public instrument. This applies to incorporeal and corporeal property. Traditio longa mano, where there is delivery by mere consent. Tradition brevi manu. The buyer is already in possession in some other capacity, as in the case where the buyer is the lessee, depository, or borrower. Traditio symbolica, where the vendor delivers the symbol of possession of the movables. With regard to movable property, its delivery may also be made by the delivery of the keys of the place or depository where it is stored or kept. And traditio constitutum possessorium. The vendor remains in possession in some other capacity for the vendee, as in the case where the vendor will now be the agent or depositary of the vendee. And negotiation of a negotiable document of title. The document of title, like a bill of lading, represents title to and possession of the property covered by the document. In delivery of incorporeal property, this is delivered through execution of a public instrument. If execution of public instrument is not applicable, it shall be delivered by the placing of the titles of ownership in the possession of the vendee, or the use by the vendee of his rights, with the vendor's consent, also known as quasi-tradition. And there can be no delivery in public instrument is executed in the following cases. If the intention of the parties is that there is no delivery despite such execution, if the vendor has no control or control over the thing to be effective, there should be no impediment to actual transfer of possession. Material delivery should be possible or could have been made. Thus, there is no delivery if a third person claiming ownership is in possession. It is essential to distinguish between a contract to sell and a conditional contract of sale, especially in cases where the subject property is sold by the owners, not to the party the seller contracted with, but to a third person, as in the case of Spouses Roque versus Aguado, GR 193778, April 7, 2014. In a contract to sell, there being no previous sale of the property, a third person buying such property despite the fulfillment of the suspensive condition, such as the full payment of the purchase price, for instance, cannot be deemed a buyer in bad faith, and the prospective buyer cannot seek the relief of reconveyance of the property. There is no double sale in such case. Title to the property will transfer to the buyer after registration because there is no defect in the owner-seller's title per se, but the latter, of course, may be sued for damages by the intending buyer. Article 1544 on double sale. Double sale does not exist if one is a contract to sell. Requisites. The two or more sales transaction in issue must pertain to exactly the same subject matter and must be valid sales transactions. B. The two or more buyers at odds over the rightful ownership of the subject matter must each represent conflicting interests. And C. The two or more buyers at odds over the rightful ownership of the subject matter must each have bought from the same seller. Cheng versus Ginato and Spouses Roca versus Aguado, GR number 193778, April 7, 2014. Problems. Miguel, Carlos, and Lino are neighbors. Miguel owned a piece of registered land, which both Carlos and Lino wanted to buy. Miguel sold the land to Carlos. The sale was not registered upon the request of Miguel. Later on, the same property was sold by Miguel to Lino. Miguel told Carlos about the second sale. Carlos immediately tried to see Lino to discuss the matter and inform him of the previous sale to him, Carlos, of the same property, but Lino refused to see Carlos. Thereupon, Carlos annotated in the registry of property his adverse claim of the property. A week later, Lino registered the sale on his favor and had a new transfer certificate of title issued in his name. However, the adverse claim of Carlos was duly annotated in title. Notwithstanding, Lino took possession of the property and built a small bungalow thereon. Who is the rightful owner of the property? Explain. To whom would the bungalow built by Lino on the property belong? Explain. Answer to letter A. Carlos is the rightful owner of the property. This is a case of double sale under Article 1544 of the New Civil Code. Carlos is the oldest title in this case because he is the first buyer. Lino's registration cannot be considered registration in good faith because he was already aware of the previous sale to Carlos. In addition, the annotation of the adverse claim serves as notice to Lino of the claim of Carlos. Since Carlos is the first buyer, the annotation of the adverse claim cannot be considered in bad faith. Answer to letter B. The bungalow built by Lino belongs to Carlos. Lino is a builder in bad faith because at the time he constructed the bungalow, he was already aware of the defect in his title because of the previous sale to Carlos. Article 449 of the New Civil Code provides that the builder loses what he built without indemnity. A and B sold to C an unregistered lot. The deed was not registered, but C took possession. Later, D obtained a judgment against A and B, and the lot in C's possession was levied upon and sold by the sheriff to D. The sheriff's sale was registered. All the parties acted in good faith. Who has better right to the land? Answer. C has better right to the land. The present case involves an unregistered land, hence Article 1544 of the Civil Code does not apply. Accordingly, the person with the older title, C, is entitled to the land. In addition, in an execution sale, the right of the highest bidder is subject to the better right of other persons over the property levied upon and sold at execution. In this case, D is subject to the better right of C. JV, owner of a parcel of land, sold it to PP, but the deed of sale was not registered. 1 year later, JV sold the parcel again to RR, who succeeded to register the deed and to obtain a transfer certificate of title over the property in his own name. Who has a better right over the parcel of land, RR or PP? Why? Explain the legal basis for your answer. Lifted from 2004 bar from the Book of AQUINO. Answer. RR has a better right over the land provided he is an innocent purchaser for value. If R is not an innocent purchaser for value, then PP has a better right. Article 1544 of the New Civil Code provides that in case of double sale, the buyer who first registers the sale in good faith acquires a better right to the land. Hence, if R is a buyer in good faith, he will have a better right. It should be noted that RR will be considered in good faith even if he relied merely on the torrent's title, because any person dealing with titled property can rely solely on what appears on the title. Therefore, for registered lands or real property, the first to register has a better right. For unregistered lands, Act 3344, registration is without prejudice to a third person with a better right. First in possession in good faith has a better right. What is an option contract? This is a contract whereby the prospective buyer, for a consideration distinct from the price, is given the right to purchase the thing to be sold. And this is asked in 1975, 1993, 1996, 2002, 2012, 2013, and 2014 bar exam. An accepted unilateral promise to buy or sell a determinate thing for a price certain is binding upon the promisor if the promise is supported by a consideration distinct from the price. An option contract is a preparatory contract that is not binding unless it is supported by a consideration that is separate from the price. The buyer is not duty bound to purchase the thing to be sold. Even if there is no separate consideration, there is a perfected contract of sale if the offer is accepted before the offer is withdrawn. 1996 and 2013 bar exam. Examples from the Book of AQUINO. Mr. A, the owner of a lot, gave Mr. B the right to purchase the lot for $1 million for a period of 1 year. Mr. B paid Mr. A the amount of $5,000, such right to purchase within 1 year. There is an option contract in this case. Number 2, if in the first example, Mr. B did not pay the 5,000 or any amount for the option, also called option money, Mr. A is free to sell his lot within 1 year. He is not required to hold on to the property. However, even without paying any option money, there will be a perfected contract of sale the moment Mr. B accepts and communicates to Mr. A that he agrees to purchase the lot for the stipulated price. Sergio is the registered owner of a 500 square meter land. His friend Marcelo, who has long been interested in the property, succeeded in persuading Sergio to sell it to him. On June 2, 2012, they agreed on the purchase price of 600,000 and that Sergio would give Marcelo up to June 30, 2012 within which to raise the amount. Marcelo, in a light tone usual between them, said that they should seal their agreement through a case of Jack Daniels, black, and 5,000 pulutan money, which he immediately handed to Sergio, and which the latter accepted. The friends then sat down and drank the first bottle from the case of bourbon. On June 15, 2013, Sergio learned of another buyer, Roberto, who was offering 800,000 in ready cash for the land. When Roberto confirmed that he could pay in cash as soon as Sergio could get the documentation ready, Sergio decided to withdraw his offer to Marcelo, hoping to just explain matters to his friend. Marcelo, however, objected when the withdrawal was communicated to him, taking the position that they have a firm and binding agreement that Sergio cannot simply walk away from, because he has an option to buy that is duly supported by a duly accepted valuable consideration. Does Marcelo have a cause of action against Sergio? Asked in 2013. Answer: yes, Marcelo has a cause of action against Sergio. Even if there is no separate consideration for the option, there is a perfected contract of sale if the offer is accepted before the offer is withdrawn. Article 1324 of the New Civil Code provides that an offer can be withdrawn at any time before acceptance. In the present case, the offer was not withdrawn before acceptance by Marcelo. Hence, it does not matter that there was no consideration separate from the price. A granted B the exclusive right to sell his brand of maong pants in Isabela, the price for his merchandise payable within 60 days from delivery, and promising B a commission of 20% on all sales. After the delivery of the merchandise to B, but before he could sell any of them, B's store in Isabela was completely burned without his fault. Together with all of A's pants, must B pay for A for his lost pants? Was asked in 1999 bar. Yes, B must pay for the lost pants. The contract involved was a contract of sale. This is indicated by the fact that the price shall be paid within 60 days from delivery. Hence, B was not merely supposed to remit the proceeds of the sale. B must pay the price. The fact that 20% commission is agreed upon is more of an agreement for a discount rather than actual commission as an agent. Since a contract of sale was involved, the ownership over the pants were transferred upon delivery. As the owner of the pants, B must bear the loss. Res spirit domino. C Corporation is the owner of a building. The building was leased to MT for a period of 5 years. The contract of lease includes a paragraph which reads that if the lessor should desire to sell the leased premises, the lessee shall be given 30 days exclusive option to purchase the same. In the event, however, that the leased premise is sold to someone other than the lessee, the lessor is bound and obligated, as it hereby binds and obligates itself, to stipulate in the deed of sale thereof that the purchaser shall recognize this lease and be bound by all the terms and conditions thereof. A. Is there an option contract between C Corporation and MT by virtue of the above quoted provision? No. The contractual stipulation provides for a right of first refusal in favor of MT. It is not an option clause or an option contract. It is a contract of a right of first refusal. When MT agreed to the lease, it is in effect stating that it consents to lease the premises and to pay the rentals agreed upon. provided the lessor also consents that, should it sell the leased property, then MT shall be given the right to match the offered purchase price and to buy the property at that price. Suppose E Corporation sold the building to E Corporation without first offering the same to MT, and the board and the officers of E Corporation knew and read the above quoted provision. What are the remedy of MT? MT can ask the court to rescind the contract and to compel C Corporation to allow MT to exercise its right of first refusal. On the part of E Corporation, it cannot be a buyer in good faith because it bought the property with notice and full knowledge that MT had a right to or interest in the property superior to its own. Equatorial Realty Development et al. Versus Mayfair Theater, GR 1060-63, November 21, 1996. Mr. A owns an undetermined number of sacks of flour in his warehouse. He entered into a contract of sale whereby he sold one half of all the contents of the warehouse to Mr. B, but with an agreement that such one half is around 200 sacks of flour. He paid the corresponding price for such one half. It was later discovered that there are only 150 sacks of flour in the warehouse. Can Mr. B recover the deficiency of 50 sacks of flour? Yes, under Article 1464, it provides that there may be a sale of an undivided share of a specific mass of fungible goods, though the seller purports to sell and the buyer to buy a definite number, weight, or measure of the goods in the mass, and though the number, weight, or measure of the goods in the mass is undetermined. If the mass contains less than the number, weight, or measure bought, the buyer becomes the owner of the whole mass, and the seller is bound to make good the deficiency from goods of the same kind and quality, unless a contrary intent appears. Distinguish option money and earnest money. Option money is not part of the price because it is a consideration in a separate contract of option, while earnest money is part of the purchase price. Hence, there is already a perfected and binding contract of sale if earnest money is paid. 1993 and 2002, bar. Give the exceptions where delivery to the carrier does not transfer ownership. Answer: where goods are shipped and by the bill of lading, the goods are deliverable to the seller or his agent, or to the order of the seller or of his agent, the seller thereby reserves the ownership in the goods. Where goods are shipped and by the bill of lading, the goods are deliverable to order of the buyer or of his agent, but possession of the bill of lading is retained by the seller or his agent. The seller thereby reserves a right to the possession of the goods as against the buyer. Where the agreement of the parties is that there is no transfer, including the bill of lading, contains provisions that indicate that the goods are still at the seller's risk. This is true, for instance, with the bill of lading contains the notation CIF, point of destination. Give the exceptions where there is transfer of ownership even if the seller is not the owner of the things sold. 1. Estoppel. The owner of the goods is by his conduct precluded from denying the seller's authority to sell. Number 2. Transfer of ownership is provided for under any Factors Act, recording laws, or any other provision of law enabling the apparent owner of goods to dispose of them as if he were the true owner thereof. 3. The sale is rendered valid under statutory power of sale or under the order of a court of competent jurisdiction. 4. Purchases made in a merchant's store or in fairs or markets in accordance with the Code of Commerce and special laws. S. An American resident of Manila, about to leave on a vacation, sold his car to B for $2,000 US. The payment to be made 10 days after delivery to X, a third-party depository, agreed upon, who shall deliver the car to B upon receipt by X of the purchase price. It was stipulated that ownership is retained by S until delivery of the car to X. 5 days after delivery of the car to X, it was destroyed in a fire, which gutted the house of X without the fault of either X or B. Is buyer B still legally obligated to pay the purchase price? Explain. It was in a 1981 bar exam. Yes, buyer B is still legally obligated to pay the purchase price. The problem states that the loss of the car occurred 5 days after delivery. Hence, B is already the owner of the car pursuant to the agreement that there is transfer of the right of ownership over the car to B. Warranty against hidden defect. Article 1561. Example. Warranty against hidden defect. Article 1561. Example. Knowing that the car had a hidden crack in the engine, X sold it to Y without informing the latter about it. In any event, the deed of sale expressly stipulated that X was not liable for hidden defects. Does Y have the right to demand from X a reimbursement of what he spent to repair the engine plus damages? 2011 bar. Yes, X is liable to pay damages. Although the problem mentioned hidden crack in the engine, the defect was not hidden to X because the problem states that X did not inform Y of the defect. Since X was in bad faith, X is liable for the consequences of the defect, including the expenses incurred for the repairs. In fact, even if X was not aware of the defect, X is also liable for breach of warranty against hidden defects under Article 1566 of the New Civil Code. Example of Recto Law, Article 1484. O, owner of a copying machine, leased it to L at a rental of $4,000 a month for a period of 1 year with option on the part of L to buy the copying machine at the end of the year for $80,000 to be paid by applying the rentals, so that L needs only to pay $32,000. L failed to pay rentals for the 4th, 5th, and 6th months, so that O terminated the lease and repossessed the copying machine, then sued L for the unpaid rental of 3 months, or $12,000. Is O's suit legally tenable? Explain. Answer. O's suit is legally untenable. Article 1485 of the New Civil Code provides that the Recto Law, Article 1484, applies to contracts purporting to be lease of personal property with option to buy, when the lessor has deprived the lessee of the possession of enjoyment of the thing. Under Article 1484, the seller has 3 options in case of non-payment of the installment, that is, specific performance, rescission, or foreclosure. In this case, O, in effect, availed of the remedy of rescission. Hence, O cannot recover the unpaid rentals because rescission involves mutual restitution and no action can be maintained for enforcement of the contract. Number 2. A sells his car to B, a compadre. If A and B fix the price of $500,000 payable in installment, secured by a chattel mortgage on the car and a real estate mortgage by a third party upon foreclosure of the chattel mortgage, may A foreclose the real estate mortgage for the unpaid balance? Answer. No. The real estate cannot be foreclosed for the unpaid balance. This is a sale of personal property on installment basis covered by Article 1484 of the New Civil Code, or the Recto Law. The said law prohibits recovery of any deficiency in the price if the seller opted to avail of the remedy of foreclosure of the chattel mortgage. There will be circumvention of this rule if foreclosure of the real estate mortgage will be allowed, because ultimately it is B who will be made to pay the deficiency. The third party has the right to ask for reimbursement from B in case the real estate mortgage will be foreclosed. Number 3. I will continue with the examples on my next audio, but if you are not yet a subscriber, please hit that subscribe button and be notified with my next audios. Thank you.